the skepticism of what you're reading in other people's summary of the law, including mine, folks, is something that should apply anytime anyone's making representations of what the law is, because these web pages that I just showed you are not sources of law. The internet generally is not a source of law. The retired cop down the street is not a source of law. What I say is not a source of law. I like to think of myself as an educational channel to connect you to the actual sources of law. But the actual sources of law, folks, are statutes, court decisions, and kind of jury instructions. Now, statutes, of course, are the laws passed by the legislature, signed by the governor. That's what we normally think of as laws. But appellate court decisions, case law, are just as robust a source of law as statutes. In fact, I would suggest that in some respects, they're stronger, because statutes by themselves don't have any effect in the real world. They're just words written on paper. Statutes don't have an effect in the real world until they're interpreted and applied by courts to real people in real cases. And it's not unusual for courts to interpret statutes in a way that the legislature might think, hey, that's not what we meant. That wasn't our intent. Sometimes courts read words into and out of statutes. So you don't really know what a statute means just by the plain English reading of the statute, because it doesn't mean that necessarily. What it means, practically speaking, is what the courts say it means. So this case law is very important. If all you've done is read your state statutes on any area of the law, but including self-defense law, and you haven't read the court decisions that interpret and apply those statutes, you don't really know what those statutes mean. So statutes, case law, those are authoritative sources of law. And you'll note that that's what I look to when I'm sharing law with you. This is a Colorado statute of their quote unquote make my day law. Because I want you to have the confidence to know that it's not just Attorney Andrew Branca making some claim about the law. I show you the actual law and I help you understand it. Jury instructions are interesting because jury instructions are not really sources of law. They're not authoritative sources of law. They're generally often created by a state Supreme Court. We'll pull together some legal experts. So in the old days, when there was a trial, the lawyers would, on opposing sides, would write up the jury instructions they would prefer the jury to get. And then the judge would get both of those offers, and he'd have to reconcile them into something he was willing to instruct the jury on. And of course, if it was a criminal case, the prosecution would be writing a version of the jury instructions that was favorable to the prosecution, and the defense would be writing a version of the jury instructions that was favorable to the defense. And each individual judge in each individual case would kind of have to amalgamate those into a single set of instructions. Well, as you might imagine, that led to highly varied jury instructions in different cases, and similarly situated criminal defendants were getting much different jury instructions. And of course, the jury instructions in theory control the verdict. They're the instructions to the jury about how to apply the law to the facts as the jury believes those facts to have been proven or disproven. So pretty much every foreign jurisdiction, maybe with the possible exception of Rhode Island now, has standardized, or sometimes they're called pattern jury instructions that are supposed to be applied, in the same way to similar cases. They're not, jury instructions are no longer just created on a case-by-case basis. And typically a state Supreme Court will pull together committees of lawyers, judges, law professors, and they'll look at the statutory language, and they'll look at how that language has been applied, interpreted and applied by the appellate courts. And from that, they'll distill a set of jury instructions that are consistent with the statutes and how they're applied. And they translate the legalese of statutes and court decisions into plain English to the best of their ability, because, of course, ultimately the instructions are intended for non-legal professionals, right? Just jurors, just lay people who won't understand the legalese. So it needs to be translated into normal English. So the jury instructions are very useful in that respect, in that they often provide a very robust, plain English explanation of the law, covering both the statutory language and the interpretation application by the appellate courts. But But if there's a disagreement between a jury instruction and the statute, or jury instruction and the appellate law, it's the jury instruction that's wrong. It doesn't by itself have any legal authority. So, folks, if the stakes are high, and in use of force cases, the stakes are pretty high, right? If you screw it up, you could be looking at the rest of your life in prison. If the stakes are high, you owe it to yourself to know the actual law of self-defense in your particular jurisdiction. And a good way to do that, by the way, is to, I don't need that to be a scrolling banner. Here at Law Self-Defense, we have state-specific courses for all 50 states. That's where I get these slides from that I share with all of you. These are the slides we use in those courses. And you can get the course for your state at lawofselfdefense.com/state as a DVD or instant online streamed, whatever you prefer. And that way, you know the actual law of self-defense.